Greetings to one and all. I'll begin with a philosophical riddle that asks, if a tree, huge tree, falls deep in the forest where there's nowhere around, does it still make a noise or a sound? The scientific view is that there could be some waves in the air, but to make a sound, it takes an ear to hear. In this age of technology where we are more often speaking to a camera or to a computer, we really wonder whether this communication is complete, that we are talking and whether somebody is really listening. So I truly appreciate each one of you who have clicked that button and hearing this talk. When I was asked to speak, my team and I wondered what would be the good topic to speak on, because many topics have been spoken about. We saw that the most popular topic is force measure. I'm not going to talk about that, but at the same time, there are many aspects of it that needs to be reached to more and more people, because circumstances requires that. But when we saw on force measure, we realized, and you also must have realized, that the essential feature required to apply force measure is the requirement of having such a clause in an agreement. So we wondered that in situations where there is an agreement and there is no force majeure clause, or there is no agreement at all, then in such circumstances, what's the legal principle that would be applicable? And in our research, we found that this ancient Latin maxim, which is called as lex non cogit ad impossibilia. Lex non cogit ad impossibilia. Let's not stress too much about how it is pronounced or the pronunciation of that. Simply put, in simple language, this maxim means law does not compel a person to do that which cannot possibly be performed, and the law will generally excuse a default if a party is unable to perform a duty created by law due to the impossibility. We felt that this is a maxim that we should talk about, which will help everyone, not only the legal fraternity, even to a common man, to understand how he can apply this principle, he or she can apply this principle to the situation. So this talk involves sharing with you the essential features of this legal maxim, how the courts have applied it, and in what situations the courts have applied it. And we're going to share with you some case laws. It will be in a slide format also, so that it will help you to capture them, so that you don't need to go rewind and forward again and again. Then finally, after that, I'll also talk to you about how this maxim applies to lease and rental agreements and to employment contracts. And in our research, we also saw that this maxim has been used in all legal systems. And the English courts in India have been using this almost since the 18th century. There were many cases which we came across in the 19th century, that's early part of 19th, that is 1900 onwards actually, which has used this principle. But somehow I felt the facts of those cases are not so much, in the sense that those facts, if they are present situation, I don't know if the courts would apply this principle. So therefore, the case laws which we are going to share with you, um, that is the pre-independent case laws, will be just where this principle has been explained upon. And one of the good explanations that we found was by the Bombay High Court in the year 1938 in the case of Emperor versus Ganpat Lakshman Kagutkar, AIR 1938, Bombay 2427. The court finds that the duty imposed is either impossible of performance and beyond the normal capacity of a reasonable or a prudent man, or when performance in the strictest language of the enactment is either idle or impossible, then the enactment must be understood as dispensing with the strict performance of that duty. Before I share with you the various other High Court decisions, we'll just look at this recent Supreme Court decision given in the year 2005. It is in the case of Haryana Urban Development Authority versus Babeshwar Kanhar, AIR 2005, Supreme Court 1491. The facts of this case in concise manner would be that there was this Babeshwar Kanhar who had applied for a site or a land allotment, and the development authority had allotted the land against a non-refundable deposit. After the allotment, the person decides he doesn't want the land anymore, and he writes stating that he's giving up his right over the land and he would like the allotment to be cancelled. But as per the scheme of the development authority, there was a deadline within which this communication had to be made. The court saw that the communication, though made, reached the Urban Development Authority after the closure period of that authority. And the Honorable Supreme Court therefore applied this principle and said the following. The Supreme Court relied on the principle lex non cogit ad impossibilia, observed that the allottee cannot be put to loss for the closure of the office of the Huda, and that in fact the allottee had no control over these matters. Now there's another decision of the Honorable Supreme Court. I cannot say that this is a decision which has given relief to the party by applying this principle, but nevertheless in this decision this principle of impossibility has been recognized and written about, and this is the case of State of Rajasthan versus Shamsher Singh. The citation is 1985 AIR 1082. In my opinion, as I said, I don't know how far this principle was applicable to that case, but the Honorable Supreme Court did take note of it, and it says the following. It has been indicated in this maxim that however mandatory the provision may be, where it is impossible of compliance, that would be a sufficient excuse for non-compliance, particularly when it is a question of time factor. So we've seen 3 case laws so far, and none of these case laws had any force majeure clause, and the courts looked into in such a way that if a given act was impossible of performance for various reasons, then the act was either excused or more time was given or the person was acquitted with. So reading of these 2 Supreme Court cases, both of Huda and State of Rajasthan, and the earlier English court cases where this maxim has been applied, and more so the remark of the court or the observation of the court to the effect that for time limits this principle or this maxim will apply, assumes a lot of importance in the present circumstances. Why I say so is that no doubt many regulatory authorities have extended compliances times, but in private contracts where there are time limits, or in many other enactments like Transfer of Property Act or Negotiable Instrument Acts, or many such enactments where there is some time limit given within which something has to be done, then a party can use this maxim to say that during this period of lockdown, at least, the performance had become impossible. Now, the next decision that I want to share with you is of Rajasthan High Court, and this is a case law where a tax benefit was given, and the condition was that for 6 years continuously the power generation has to take place. The concerned SSE had availed the sales tax benefit, but due to a natural calamity the mill had was destroyed and they could not perform their part of the obligation, and the court accepted, and based on the principle of the maxim that we are talking about, the court did give a relief in this case. And the court said the following: the language used in the said clause cannot be interpreted to read that even if due to factors beyond the control of industrial undertaking, if the wind farm cannot be kept in a running condition, there would be a breach of the said condition. The condition incorporated in the said clause deals with a voluntary action on the part of the industrial undertaking. The said clause can be invoked for withdrawal of the benefits if it is found that the either deliberately or due to gross negligence on part of the industrial undertaking, the wind farm was not kept in a running condition. So, in our opinion, if the act of discontinuing generation of electricity is deliberate or voluntary, then only the concerned industrial undertaking should be deprived of the benefit availed under the scheme. Now, I read these paragraphs in detail for only to bring your kind attention that the courts will certainly see whether the non-performance or of the obligation was deliberate, or whether it was on due to negligence, or it was whether purely on the basis of impossibility. So this was the highlight of this case, and that's why I thought let me share this with you. Next, we'll quickly see a few cases. These three pertain to impossibility not due to the fault of that person. So I'll briefly probably state the facts in each case. In case you are also similarly facing similar facts, probably that will help you. Now, in the case of Varghese, Archana Varghese's case, the Kerala Land Utilization Order of 1967 required that in order to convert a given land, the condition was that paddy crop should be grown continuously for a period of 3 years. So here was a land where the land itself was uncultivable. So in such circumstances, the court held that this fault cannot be attributed to the party, and then relief was given to the said party. Next is Punjab National Bank case. This is also very unique facts in the sense that after the property was brought to sale, the decree had at the time of sale, the decree had said that the interest on the principal amount should be paid until the entire principal is recovered. So after the sale, some objections were raised and the objectors went all the way to Supreme Court, and there was an enormous delay. Then question arose, who should pay the interest? The court found that the person who had purchased, it is not his fault, and so he was not required to pay the interest. And in this Pune Electricity Company case, this was a situation where under the Indian Electricity Act, there was a requirement that the cause of the accident should be reported within 24 hours. So this accident, in this particular accident, it could not be reported because the persons involved were incapable. I think they were in coma or some such situations, and therefore they could not say. So the court held that this need not be complied with, and so it's not for the fault of that person. Next, we have this safe pack polymers case. Again, this was also a bit unique in the sense that the directors were asked to produce some records, and these records were damaged by the militant laborers and workers. So once it was established that the records itself were damaged, this impossible principle was applied in this case, and then it was held that the records could possibly not be produced because it was impossible to produce the same. So far, I've shared with you those case laws in which this principle was accepted. However, there are many cases in which this court has not accepted this principle, in the sense that it has said that it's not applicable to the fact and circumstances of that case. And in that, two cases that we will just talk about and I'll share with you. The first one is in the case, it was also by the Bombay High Court, and it was in the case of Raymond Synthetics Limited versus Union of India, 1992, 1 Bombay CR 133. Now this was a case where certain refunds had to be paid as against some debentures distribution. I don't recollect. So these refunds had to go within a time limit which was set by the SEBI. The company had asked for extension, and I don't think so the extension was given. There was a fire, and there were lakhs of refunds that had to be given. And so the company took up a contention that it was impossible to uh, give refunds within the time limit that was set by the SEBI. The court did not accept, and it felt that the company had resources or could have given the refunds within the time limit, and so it did not apply this principle of impossibility, and then the petition was dismissed. Now, apart from this, there is one other decision that I want to share with you, and this is where the court has very categorically held that there has to be a difference between impossibility and inability or incapability. And it is in the case of DSJ Communication versus Union of India. We couldn't get the citation for this, and the High Court made a distinction between inability and impossibility for performance. An analysis of all the cases, that is, which has applied and upheld this principle and which has refused to apply, there are three essential elements that I could analyze, and I can put it in this form. That is, one, whether the event, that is the non-compliance, was beyond the control of the person. B, occurred without any fault of that person. And C, it resulted in an impossibility. While the decisions that I have spoken about, we have taken those facts which I felt were a little relatable to the present situation. There are many other decisions of the Honorable Supreme Court which has taken note of this maxim, and that is in relation to the impossibility of punishing a company as such, or imprisoning a company. So those list of case laws, I will put it in the list of all the case laws in a slide in some time. And now, to sum up this principle, as you have seen from the case laws, from the analysis of the principle as such, we have also shown you the essential three ingredients that should be present. Now, this will take us to the point that it is the onus is on the person who applies this principle to also establish the existence of them. And so there's a lot of evidence, and the skill of an advocate, the skill of the person who's putting up the case becomes very important. When I talk of skill of an advocate, there is a old story that I had read, which was in Canada, and then I want to share with you. There was this man who deeply wanted to go to Kashi, and somehow it just didn't happen. Then he got married, and then it didn't happen. Then he had a child, it didn't happen. uh, Suddenly his wife passed away, and then he felt that now he has to go, come what may. And but he has a small son, so he requests his neighbor, who is also a wealthy, comfortable man, to take care of his son while he undertakes this pilgrimage. So the both of them come to an agreement that mm, the this man will give his neighbor about 100 gold coins, which is quite a bit whenever this story happened. And in turn, this neighbor will take care of his son. So they agreed that if when he comes back, the neighbor will deduct the expenses that he has incurred for the son and give the rest back to the man. And in case the man doesn't return, he says that please give whatever you want for my son after taking due care of him. And he can go and make his life with that. So this agreement happened, and then the man went to Kashi. After a few months, a news came that he was no more, and so he won't be coming back. The relatives of this boy who were living far away come to take him, and the villagers also come. And then they say that you need to honor the terms of the agreement and give him something so that the relatives can take care and he can also take care of his life. So the neighbor gives him about 5 coins and says, now you can go, because the agreement was that I should give what I want, and I've given him. So the relatives and villagers are very sad about it. And just then they come across a wise counsel like you. And so the person says, the lawyer says, okay, I will help you. So the wise man goes to the neighbor's house and he says what happened. And so it is narrated to him. So the wise counsel asks him, how much have you given the boy? So he says 5 out of 100. So how much have you kept with you? So he says 95, and that's simple mathematics. So he says, why have you kept that? He says, that's what I want, is what the neighbor says. So then the wise man says, see, the agreement was to give it to the boy what you wanted. Now you tell me you wanted 95. So therefore you should give 95 to the boy. So we are famous for playing with our words. And I hope there is sufficient material in front of you to help yourself and to your parties and clients to try and get over the difficult situations which we may face and hope we may not face. So to end, I have 2 things to mention. One is that the High Court decisions that I have spoken and the citations that I would share with you are, to our knowledge and understanding, have become final. But in case we've missed out on something that has been overturned or overruled, I stand corrected on that. And the second point is that in the beginning of the talk, I had mentioned that we'll also examine how this principle is applicable to employment contracts and rental agreements. I'm going to bring a second part to this, and that will be exclusively dealing with this aspect. If you have any feedback and queries, please send it to the Sunday Club team. I thank them for this opportunity. And pandemic has been an unprecedented, most challenging times for all of us. Each one has dealt it in different ways. I only pray God that we get that immunity to face the challenge in future, and the courts open fast, and so that we all can meet each other And until then, please take care and see you all soon on the second part again. Bye.